Senator Jillian van Turnhout to move her motion. Senator, you have 4 minutes.
Thank you very much, and I welcome Minister O'Sullivan to the House. And while I very much welcome you, I would have loved the opportunity to officially congratulate Minister Fitzgerald on the successful passage of the children's referendum, because unfortunately we haven't seen her in this House since the referendum. But my motion tonight is in relation to direct provision. Much of the public awareness and outcry about the abuse and mistreatment of children in the state-run institutions came through the publication of a series of damning reports, such as Ferns, Ryan, Murphy and the Cloyne report, and most recently the Child Debt Review report by Dr. Jeffrey Shannon and Nora Gibbons. In response to the latter report, I expressed my profound sadness and a sense of responsibility and shame I bear as a member of society that has systematically failed to protect our most vulnerable children. Minister Fitzgerald, at the launch of Amnesty International's In Plain Sight, responding to the Ferns, Ryan, Murphy and Cloyne reports last year, remarked that, and I quote, "At every turn, Irish people kept their mouths shut out of deference to the state, system, church and community. When they should have been unified in fury and outrage, they were instead silenced, afraid to even whisper a criticism against the powerful." End of quote. Minister, I'm genuinely concerned that the situation for children in direct provision, asylum seekers, accommodation centres will be our Ryan report of the future, unless immediate action is taken. And I refuse to stay silently complicit. This is not an easy area to pursue, even though I am at this juncture focusing only on the situation for children in direct provision. I'm finding it difficult to establish which ministerial remit covers which scenario. I have, for example, already addressed an adjournment motion to your Cabinet colleague, Minister Shatter, TD, Minister for Justice and Equality, about the applicability of Standard 3.4 of HICWA, National Standards for the Protection and Welfare of Children. And this standard clearly stipulates child protection and welfare services provided on behalf of statutory service providers are monitored for compliance with legislation, regulations, national child protection and welfare policy and standards. In my opinion, the HICWA national standards for the protection and welfare of children clearly apply to children in direct provision. They apply because these children are children residing in accommodation facilities under the remit of the Department of Justice and Equality. They apply irrespective of the children's country of origin or the status of their parents, and irrespective of whether they are in the care of the state or cared for by the state. They apply because it is simply untrue, as suggested by Minister Shatter, that all children living in direct provision live in a family context and their parents and guardians have primary responsibility for their care and welfare. This is not true. In this regard, I refer you to the Irish Refugee Council's report entitled State-Sanctioned Child Poverty and Exclusion, the Case of Children in Accommodation for Asylum Seekers, which was published in September. And also the Special Rapporteur reports by Jeffrey Shannon, the 2011 report, where he highlighted the very specific vulnerability of children accommodated in the system of direct provision and the potential of actual harm which is being created by the particular circumstances of their residency, including the inability of parents to properly care for and protect their children. They apply because the state has an obligation to ensure the health, safety and welfare of these children. Minister Shatter did concede that the HICWA standards do apply to the HSE Child and Family Services in the context of its role in dealing with any children living in direct provision who are referred to it, with such referrals capable of being made under RIA's child protection policy or, for example, by GPs or teachers. And these scenarios, according to the HSE, fall under the remit of the Minister for Children. And so my question to Minister Fitzgerald is, my question to Minister Fitzgerald is to seek clarification on the number of referrals the HSE has received about children in direct provision accommodation centres, and I want to know whether the Minister shares my position that any centre from which a child welfare and protection referral is made be subject to immediate inspection according to the HICWA national standards.
Thank you, Senator. Minister.
Thank you, and I'd like to thank Senator Van Turnhout for raising this issue, and I will convey your concerns, and I'm sorry that Minister Fitzgerald is not here to reply. At the outset, I'd like to clarify that the Reception and Integration Agency is a functional unit of the INIS, which is a division of the Department of Justice and Equality. RIA is charged with providing accommodation and ancillary services to asylum seekers, i.e. adults and their children, under the direct provision system. While their applications for asylum are processed, direct provision centres are monitored 3 times a year, twice by the Department of Justice staff and once by an external company. Under Children First national guidance for the protection and welfare of children, any concerns about the welfare, safety or well-being of a child should be reported to the HSE Children and Family Services. The Child Protection and Welfare Policy of RIA reflects this practice. The HSE received approximately 31,000 reports last year. Reports regarding children residing in direct provision accommodation are included in this number. The RIA has advised that there were 171 referrals for a range of child protection and welfare concerns for family units in direct provision accommodation to the HSE Children and Family Services in 2011. These included a significant number of welfare concerns, such as a parent being hospitalised, parental illness, a child being left unsupervised by an adult, mental health concerns regarding the parent, etc., and a smaller number related to child protection concerns. Such referrals can be made under the RIA Child Protection Policy by staff and other residents, but may also be made by GPs, teachers, etc. There is a specific unit within the RIA, the Child and Family Services Unit, whose role is to manage, deliver, coordinate, monitor and plan all matters relating to child and family services for all asylum seekers residing in the direct provision system. This unit also links, where necessary, directly with the Gardaí. As the Senator's question relates specifically to the application of the HICWA national standards for the protection and welfare of children, I wish to outline the position regarding these standards. In July 2010, the Government decided to prioritise the inspection of the HSE Child Protection Service by the Health Information Quality Authority. The first of these inspections took place this month and are undertaken against standards developed by HICWA as provided for by the Health Act of 2007. As part of the inspection process, HICWA inspects the HSE Child Protection Services at all levels, from national management to social work team level. HICWA developed the national standards for the protection and welfare of children in consultation with a wide range of stakeholders. The national standards apply to the HSE Children and Family Services and the performance by the HSE of the duties placed on the HSE under Section 3 of the Child Care Act of 1991. The standards set out the key features of an effective child protection service. They clearly put the needs of children at the heart of that service and promote the principles outlined in Children First, the national guidance for the protection and welfare of children. The standards are designed to follow a child's journey within the HSE child protection system to ensure that his or her safety is being protected. They describe how the services should be provided and examine the use of resources, information and management of service. The national standards apply to the HSE Children First and Family Services in the context of its role in dealing with all referrals to its service, including referrals regarding children living in direct provision accommodation. It is essential to ensure that a child's safety is being protected while they are receiving a service within the HSE child protection system. It is critical that services for children are of a high standard, and these standards are important to set out clearly what a child and his or her family can expect from the HSE Children and Family Services. We need the evidence of good practice in child protection to be applied uniformly, and these standards are a key part of that. These will be a critical aspect of the external quality assurance infrastructure and support continuous improvements for children's services into the future. HICWA currently inspects all residential services run by the HSE for children who are in the care of the state. HICWA does not inspect the accommodation provided under the direct provision system or other similar services such as homeless services or refuges for those experiencing domestic violence. Children living in the direct provision system are not in the care of the state. All live in a family context, and their parents or guardians have the primary responsibility for their care and welfare.
Minister O'Sullivan, supplementary questions?
Just very supplementary. I appreciate that the Minister won't be able to answer this question. I have a huge difficulty of the differentiation between in the care of the state or cared for by the state. These children are directly being cared for by the state. Go visit any of these direct provision centres. They are not necessarily in a family context. You have 2 or 3 families in one room. It's not a normal family context. So I have a difficulty. I will continue to pursue this question. I feel it's a fudge. The question directly that I've asked about standards, are we basically saying that the HICWA standards do not apply, that no child protection standards apply, that we wait for referrals from the very people who are deciding the applications of these people? So you don't want to upset the Department of Justice. It would be basically for me the equivalent of asking Irish families to get the Department of Social Protection, if they're receiving benefit payments, that it's the same place that they would go to in relation to child protection concerns. It's separate for a reason. It should be independent. We should have learned from the past.
Thank you, Senator Van Turnhout. Minister, do you want final?
I can see, that you're obviously very concerned about this, Senator, and I will convey directly to Minister Fitzgerald your concerns, and I'll ask her to contact you directly with regard to your supplementary question.
Thank you.
Thank you, Senator. Yeah, now